Hi, this is Theodore Watson. Today I want to talk to you about government contracts, innovations, and some of the basic points for contractors who are buying or selling a business that already has federal government contracts. Again, my name is Theodore Watson from Watson and Associates LLC. We're government contract attorneys and consultants and business law attorneys. First point is, let's talk about what is a novation in federal government contracting. Basically, what that is originally the original parties to the contract is the federal government and the contractor or the business itself. Sometime during the performance period, either the contractor is either buying or in most cases selling the existing business that still has performance obligations to the federal government. And under FAR 42, when the parties are obviously changing, then the government is not going to be just automatically stuck with the new owner. There has to be a process that you have to go through under FAR 42 to either get the government contract novated or reach some other agreement with the government. So the simple explanation is when the original parties to a contract want to somehow relinquish their obligations to the government, then this is where you would have to go through the novation process. Common examples, as I said, include contractors seeking to get out of the business of government contracting, or in most cases, selling or buying a business that already has a federal contract. One of the things that, as an audience, you want to make sure you understand is that government contracts are not just made to be sold. Obviously, if you're selling a business and, the contract is part of, let's say, an asset purchase, then obviously the contracting agency will entertain the possibility of novating the contract over. But the main point here is that government contracts cannot be just sold as it would be in the commercial sector. To merely sell government contracts or to sell government contracts would essentially violate the Anti-Assignment Act. As I stated earlier, the novation of government contracts is governed by FAR 42.1204. So what are the basic points of FAR 42.1204? As I said earlier, since the original party signed the contract, one of those parties, normally the contractor, cannot just transfer government contracts to a third party. Why is that? Well, obviously, to get the original contract, there had to be some level of source selection, looking at your technical capability to perform, past performance, etc. So simply to just now hand the contract over to somebody else or another company without some level of review from the government creates a risk to the government. So this is where the contracting officer gets involved. Under FAR 42 and the novation regulations as a whole, the federal government may, when it's in its interest, recognize a third party as successor in interest to government contract. There's a transfer of all the assets or the entire portion of the assets involved in performing the contract. A novation requirement is not required when there's a change in ownership of the contract as a result of a stock purchase. With no legal change in the contracting party, and when the contracting party remains in control of the assets is the party performing the contract. However, as a practical matter, a contracting officer must still be involved when there's a stock purchase, even just as a matter of court courtesy. Again, if you're building relationships with the government, even though as a general practice, stock purchases don't require a novation, you still want to keep the agency involved at all costs. What are some of the potential legal problems to avoid? First thing that stands out is if you execute your asset purchase agreement and then inform the contracting officer, be aware that the contracting officer may not approve the transfer. Keep in mind is that the contracting officer only has to approve the transfer if it's in the government's best interest. What does that mean? Is if you executed your asset agreement and then you're just notifying the agency, you as the seller may still be liable for the performance of the contract. So this is where it's important that you always keep the agency involved at the beginning, especially during the negotiation process between either the buyer or the seller. If the seller fails to perform the contract, when the contracting officer decides that they're not going to approve the transfer, then as the original party to the contract, if you fail to perform, then the government can terminate the contract for default. So what inherently happens is that now you will have a potential problem with the buyer, and legal action probably against you as the seller, because now the seller is essentially in limbo with the government. So that's not usually a good situation. The other thing that you need to be aware of is that the only asset that you're selling in the government contract is the contract itself. As we said earlier, that can create a potential problem simply because the Anti-Assignment Act expressly prohibits just selling government contracts. So again, you want to be very careful there. Other situations that you want to pay attention to is, when you're transferring government contracts under the 8A program. The SBA obviously is involved from the beginning and the award stages, so you obviously have to keep them involved just as you would the original contracting officer. This goes just as well for service disabled veteran set-asides or awards, hub zone contracts that's being transferred. You want to always include the SBA. The asset purchase agreement, although meeting commercial standards, may not convince the federal government. The main point of this short briefing is that always understand that it's always whether it's in the government's interest to approve the novation or the transfer. Planning ahead is critical. As I can't emphasize enough that from the beginning stages that you are thinking about selling or buying a business, you want to make sure ahead of time that all of the requirements for FAR 42 are being complied with, and don't be reactive to the situation. This may include getting someone from the legal side that understands the process to help you from the beginning to the end. FAR 42-1204 does not establish a timeline for the novation process. However, as I can't emphasize enough, getting the contracting officer involved upfront is critical. As you decide to sell or buy a business that involves federal contract, you should immediately consider the legal requirements you need to follow. Getting the contracting officer involved is critical. Again, contracting officer does not have to approve the novation unless it's in the government's interest. Small businesses, as a small business, you may still have to certify your status after either buying or selling. Make sure that you have the people on your team that understands the procurement process, because there can be some serious snags, especially when there's a lot of money involved, or unbeknownst to either the buyer or the seller, the only thing that you have listed in your asset purchase agreement is the actual contract itself. The government attorneys, when they see that, that creates a red flag, and you may now have to deal with a transaction or business deal that may not eventually go through. If there's any questions or concerns, feel free to give us a call at 1-866-601-5518. Again, this is Theodore Watson. Thank you.